Or do you mean where am I working?
No, I'll get to that in a minute, I promise. Okay, so you're in Santa Barbara. And so what time is it there right now?
It's 8 o'clock.
Well, that's not too bad.
No, it's not bad at all.
I thought, you might be up at 4 or something like that. So you were just out speaking at the convention, or were you just attending? I assume you were speaking.
I was in Denver at the Appraisal Institute's annual meeting.
Yeah, how'd that go?
And I gave a couple of presentations. One was about predominantly appraiser overtime issues. So whether appraisers can be treated as exempt employees for overtime.
Oh.
And then related to that, I was talking about appraisers being treated as independent contractors by both appraisal firms and also AMCs, these hybrid AMCs. That's a really big legal issue for especially AMCs in the future because of some legal decisions we've had. Well, one in particular out here in California that really makes it very difficult for any kind of company that uses, like Uber or Lyft or an AMC that uses thousands of contractors. It makes it very difficult for them to legally treat those workers as independent contractors. So
interesting.
So the group for that presentation was mainly large employers of appraisers.
Yeah, but that could trickle down to even, smaller firms as well.
It really does.
And since you're speaking of that, let's just talk. And we've got a handful of viewers out there already. We haven't actually gotten started yet. We're just chatting with Peter. So if you're on early watching, you kind of get a little extra here. But Peter, I had somebody reach out to me recently with this exact topic. And I'm not going to say what state it's in, but said that they've kind of come after this guy about the independent contractor status. And some of the questions I asked, and I'm certainly not an attorney, but I said, do you provide an office for the guy? Does he only work for you? Does he have a schedule that he has to come in at prescribed time frames? And these were some of the questions that I was interested in hearing the answers to. But he's real concerned because he's afraid that he's going to have to go back and pay some of this tax, which I think is why they've come knocking at his door in the first place. So
absolutely.
So what's the real test with that? If I can...
The real test is like you described for most states and most purposes. I don't know whether that was the income tax issue audit or like a state unemployment tax or workers' comp audit. The tests would vary, but for most of the tests, it's the degree of control that the employer, who's not really supposed to be an employer here, right, because the person's a contractor, but it's the degree of control that that company exercises over that appraiser. So those factors that you mentioned are like 5 of the 20 factors the IRS would use to analyze that.
Gotcha.
And so it can be other things. Does the appraiser accept work outside of that firm? Does the appraiser buy their own insurance? Does the appraiser have a business card? Does the appraiser do their own billing? If that billing is going through that gentleman's firm, he's going to have quite a bit of a problem.
Let me ask you about that, because that's interesting that you say that. What if the billing for the appraisal is through the firm? However, the billing for the individual sends a bill to, the owner of the firm for their services as an independent contractor.
Yeah, it's just a factor. So
yeah,
that's not, none of these issues is like the end of the day for the decision, but the fact, it's just a factor. Now you could have other factors, like maybe this contractor has his own LLC or S Corp. Okay, that's going to tend to weigh on, okay, they really are independent businesses.
Right, right.
But, and something that surprises employers here is, okay, I've got this guy who's my contractor. Another firm also has him as a contractor, and a third firm has him as a contractor.
Right, right.
He could, especially in a state like California, a court could say, Well, he's got 3 different employers.
Exactly. Yeah. Wow. Wow. That's 3 part-time jobs. It's not
Yeah,
independent contractor.
exactly.
Yeah. Yeah. It's just kind of interesting. I subcontract some work out. I have a gentleman over in Indiana, an MAI appraiser over there that works with me on commercial projects. He most certainly has his own book of business, his own practice. He doesn't work with me every day or every month for that matter. You know, we'll bid a project. We've got an interesting project right now with 10 schools and then 50 schools we're working on. I don't have the time to do that. So, you know, he helps me out with that. But it is most certainly, we both have separate companies. We're just coming together to collaborate.
I don't think you'd have a problem at all in that
Yeah.
instance.
Yeah. I feel pretty safe on that. And I know a couple of attorneys I can call if I need to. so I feel a little bit better.
But then you see other types of other small appraisal firms where they literally call, you know, the people, their staff, they'll call them, here are our 1099 employees.
Right.
You know, it's an oxymoron. So
Right. No, I understand. Yeah, you got to be careful out there. Well, hey, Peter, it's 10 o'clock. It's time to get rolling here. So let's go. Good morning, appraisers. My name is Bryan Reynolds. Welcome to the Appraisal Report Webinar, brought to you by the fine folks of Appraiser eLearning. We bring these webinars to you free of charge. Glad you're here. We've got a great guest today. These sessions are being recorded, so if you have to hop off here and miss a few minutes of it and want to catch the rest, they're normally available on YouTube pretty much after the broadcast. Speaking of that, go ahead and hit the subscribe button right now so that you continue to be in the know. Occasionally, we'll have some special webinars, ones outside of that normal Thursday of the month broadcast. The fourth Thursday, we may have a special webinar, and you don't want to miss those. Trust me. So go ahead and click the subscribe button now, and then you'll know whenever we have one of those special webinars. Listen, folks, I'm really excited. We have Peter Christensen on today. He's an attorney. He's going to answer all your legal questions. I don't know about that. He's going to answer some of your questions. So feel free to type in a question during this broadcast. We do these live. They're not scripted. I have not sent Peter questions in advance of what I'm going to be asking him today, so he doesn't know. We certainly don't know what your questions are. And that's what makes this webinar unique, a little different. We do it live, it's unscripted, and we obviously love for you to be involved. So, hey, Peter, say hello to everybody and welcome to the show.
good morning from Santa Barbara, California.
Great. Hey, Peter, why don't you tell everybody a little bit about you? I know you have been an attorney for a E&O provider. So tell us your background and what you're doing these days.
Yeah, I'm an attorney. I've been an attorney for 20-something years out here in California. Worked for some very large law firms. After about 10 years of that, then I went to work for LIA Administrators, and I was their general counsel for 14 years. In June, I actually retired from that position so that I could solely work as an attorney, Christensen Law Firm. I'm still doing risk management education for LIA, traveling around the country. A lot of appraisers have seen me around the country doing my 3 to 7 hour live seminars. So that's something I'm keeping up with LIA. But other than that, I'm working as an attorney, and really my law practice is focused on valuation and insurance issues.
Great. And we're excited that you're here today because you work on valuation issues. You work with appraisers and there for a long 14 years, I believe you said you worked for an E&O provider, and your role in that organization, I assume, was, you kind of got the phone call when a claim was filed, or when, hey, E&O company, I've got a complaint filed again, or worse yet, hey, E&O company, I have a lawsuit against me. So I assume that's when you kind of sprung into action. Is that right?
Yeah, I was on the receiving end of a lot of those calls. There are a couple other people who took calls like that as well. But that was like half my day was getting claims from appraisers, discipline from appraisers, threats against appraisers. Oh, this lender sent me this letter. They're demanding that I respond to, it could be a mortgage buyback issue. We'd helping appraisers with those kinds of issues. But then a good E&O provider is also kind of a legal source for other help for appraisers as well. So there's a lot of other questions that came up from appraisers that I'd answer on a daily basis, like, oh, this contract with this AMC, it says this about indemnification. Or for larger insureds, the kind of national appraisal firms, it could be like, help us redesign our engagement agreements, that kind of thing.
Very good. Very good. Well, I know we've got a lot of folks that are going to be interested in hearing what you have to say, as am I. So let's just jump right in here. And we're not going to jump right in because first, I mean, it looks like you're in a garage. Yeah, I mean, do you have a side business there, woodworking or something, or what's going on behind you?
Do I have a side business? No, but some of my neighbors have sometimes thought while I'm very handy and do a lot of landscaping and
Nice.
fix my own machinery and that kind of stuff. And so when I don't have like a suit on, I'm out in my yard, and sometimes neighbors are walking their dogs down the street, and they will assume that I am hired to do that. I'm a professional landscaper.
I love it. Great.
I lived in a homeowners association at one point in my life where you were not allowed to have professional workers on the weekends at your home. And when I moved into the neighborhood and I was cutting my grass on a Saturday, I got reported to the homeowners association, even though you're permitted to cut your own grass.
Right.
You're just not allowed to have a professional cut it. So it's not a side business. This is my workshop attached to my garage out here in Santa Barbara. We started getting on this call at 7 in the morning. So I'm using this computer out of my workshop, but it is my favorite place to be in the world.
That's awesome. Well, it's very well organized. I see all your little bins back there behind you. Love the chainsaw, by the way. And it is amazingly organized. So, heck, you could probably offer that service as well. You'll go organize people's garages for crying out loud. It looks fantastic.
Well, I did do a little bit of tidying up before I got on YouTube, because I've given a lot of live seminars over the years, probably like 300 live seminars. This is my first time on YouTube. So I'm more nervous about being on YouTube than anything else I've done in the last 14 years.
Oh my goodness. Well, you're going to be fine. You're going to be great. So don't be nervous. We'll kid glove it as best we can. It's interesting. I had Jim Park on, and he had a big sword behind him, and had John Brennan on, and and I don't think I mentioned this in the broadcast, but he had a plaque on his wall, and he's a Kentucky colonel, by the way. So that's very cool, because I'm born, raised, and live in Kentucky, in the Commonwealth of Kentucky. But I tell you, your background may take it all so far. So I don't know if we're going to start having a contest with all the guests of having unique or awesome backgrounds, because you sure have one. Now let's dive into the subject matter. I'm ready. I'm excited, and I know we've got a lot of viewers that's going to be excited as well. And I encourage our viewers to ask questions at any time. Here's the format. We've got a great attorney here, a great resource for you. So we encourage those questions. So Peter, let's talk for a minute. And there's so many different avenues we could go down here. You even mentioned buybacks, which we'll get into a little bit later on. I'm making myself a note. I said it's not scripted. It's not, but I'm making a note so I don't forget. So before we get into those, let's talk about regulatory for a minute. Would you say that more appraisers are turned into their state board, or more appraisers are calling you because they're finding themselves in a lawsuit? Which is the higher percentage of calls that you get?
For about the last 5 years, it would be the disciplinary matters.
Okay.
That appraisers, that's more of a legal issue for an appraiser than being sued in a lawsuit for the last 5 years.
Okay.
Prior to 5 years, we had, the great mortgage problem. And so there were probably triple the number of lawsuits going in 2011, 12 per appraiser than there are now. Now, things have settled down claims-wise, and also even complaints to state appraiser boards are somewhat down in a lot of states because you don't have all that many lenders filing that many of them currently. So things across the board are pretty calm, but an appraiser is more likely to have a disciplinary matter right now than they are a full-blown lawsuit.
Yeah, yeah. So let's talk about those, and then we'll move into lawsuits in a little bit later part of this broadcast. So regulatory issues. Somebody files a complaint, you get a phone call. And I know you've got so many stories, we could talk all day on this topic, but what are some of the more common deficiencies that we find? So if I had to say, what's the top 3 mistakes that we as appraisers make?
Well, the top thing is not really a deficiency at all. The top complaint is going to be, in my view, a frivolous complaint. And unfortunately, it's going to come from a homeowner.
Yeah.
And it's probably going to say the value was too low.
Right.
That's the most common complaint across the country. And that's not only a residential appraiser issue, that's a commercial appraiser issue too.
Yeah.
That you see a commercial borrower make that same kind of complaint to a state board. So that's probably, okay. And then you'll have some borrowers, homeowners saying the appraisal was too high, but that would be about an older appraisal. And now they're feeling like, well, I borrowed too much money or I paid too much.
I'm upside down. Yeah.
So that's by far the most common. So,
yeah.
But as far as actual errors in reports in front of state boards, it would be still about value, even though many of them are frivolous. It would be, okay, the appraiser failed to make those adjustments properly, didn't select the right properties. It's just, that's the most common. Okay. And then you have other issues beyond that. So the most common error, though, outside just pure value in a regulatory complaint or in a lawsuit is going to be home measurement. If we're talking about an appraisal of a home for a mortgage, home measurement is going to be the #1 most common. And a lot of state boards won't deal with that particular issue. State board's not going to go remeasure a house. But once an investigation begins, that state board is going to get the work file, going to get the appraisal, and they're going to, they're looking at the whole appraisal now. They're not just looking at the complaint, the basis of the complaint filed by the homeowner. They're going to go through it, and they might find something else.
Yeah. How do we stop that? Because that's that's a pet peeve. So you mentioned a few things that I want to focus on here real quick, if I may. You mentioned square footage. Now, square footage is a fact. The house is only one size. However, you could send 3 appraisers out there and measure it and get different numbers, even though it's a fact. Maybe they have a different rounding technique, etc. As long as they're pretty close, I wouldn't think that's going to be a major issue. So the big issue is if it's substantially off from what it should be, right? So somebody files a complaint. Like I had a consumer contact me one time and said, "Mr. Reynolds, you got my square footage wrong." And I said, "Oh, okay." She said, "You appraised my house when I bought it. We're now trying to sell it. The real estate professional told me to call you because you're wrong. You said my house was bigger than what it is." And I said, "Oh gosh, well, first of all," I said, "you're not my client. I can't talk to you." but I realized that all that's going to do is really make them mad, right? I mean, that's probably going to prompt them to file a complaint. So what I said, while you're not my client, I can't talk to you. Let me contact the client, or you contact the client. Let's see if we have permission to talk to you, and then I'll tell you anything you want to know. And we got the authorization to talk to them. And I called them back and I said, "All right, I've got authorization. So let's walk through this together. I mean, I'm human. I might have made a mistake." Pulled the work file out, started looking at it. And again, this was a new construction. I said, "All right, well, I'm showing 1,200 square foot on the first level. And then I'm showing 400 square feet or whatever it was, the bonus room above the garage. We don't have a bonus room." And I said, "Excuse me? We decided not to do it." "Oh, well, nobody told me. The plans and specifications I have that I was given to do the opinion of value is based on." She said, "Do you mean to tell me that so I think her next call was to the builder, right? But my question is this: let's say that she did file a complaint against me, and I was able to provide that information. Say, look, this is what I based my opinion on. This was part of the engagement. I feel pretty good about that, and the issue is done. Bryan didn't get the square footage wrong, but then they go through the whole report, as you mentioned a while ago. How can we stop? Do other professions do that? I mean, is that
No,
commonplace?
I
And,
don't know how. I don't know how we stop that, but it's not common to other professions. I can't think of another profession that gets these kinds of complaints that really, gets these kinds of undeserved complaints, and that really has their work product subject to these kinds of disciplinary complaints, where the state can take your license, your means of livelihood away. If a lawyer, if I as a lawyer, I don't do something quite right in a legal brief, it doesn't work quite right in a court case, and the judge says, Mr. Christensen, I don't like your argument. I think you're really wrong about the law. The next thing that happens to me isn't a complaint to the state bar. It's just, that would be unheard of.
right.
So appraisers are in a difficult spot here.
Yeah.
Some states, appraisers in some states are trying to do some things like, a complaint to the state board could only be made by an intended user of the report. But, that's a hard argument to support legislatively, because the state board's missions there are there purportedly to protect the public.
Right.
So if you're going to say, okay, the public maybe can't sue you because they're not an intended user, we'd be saying that as well. Now they can't even file a complaint against an appraiser because they're not an intended user to the state board. It's really a difficult argument. So
yeah, I think people forget that I'm part of the public too. I am public. So appraisers are members of the public. So, where's our protection, for crying out loud? Don't treat me unfairly. It's a tough argument. It's a tough debate on both sides. So, but you had mentioned frivolous. You see a lot of frivolous stuff, and while that might be discounted easily, it opens up a whole, I hate to say witch hunt, but it opens up a whole investigation of everything they did in this case. That just seems a little brutal to me.
it is brutal.
Yeah.
In Nevada, we're kind of talking about this home square footage issue. You mentioned your own situation. In Nevada, there was recently a homeowner who sued an appraiser over a square footage issue and it was this. She was the seller here and had an appraisal done, and then years later was selling the home. She complained against the appraiser. The state dismissed the complaint, but then it went to court. She filed her lawsuit, thinking, okay, this appraiser will just settle this. Here's the thing: the appraiser had not actually made an error in the report. The square footage, what the appraiser had measured the home correctly. There was a public record where that did overstate the square footage. And she somehow had this theory that the appraiser should have done something like drawn more attention to the error in the public record. I don't even know what her real theory was, but she still filed her lawsuit and pursued it all the way to the Supreme Court of Nevada. And appealed it when she lost to the Supreme Court of Nevada. Thankfully, it was dismissed along the way. The Supreme Court affirmed the dismissal as well. But that's the lengths that some people will go to sue an appraiser, unfortunately, over something as simple as alleged measurement error that wasn't even an error.
Wasn't an error. Wow, and how long? I'm just curious, Peter. How long did that case? From start all the way to the dismissal of the Supreme Court?
I can't recall sitting right here, but it would have for sure been a 3 or 4 year whole process.
So this poor appraiser, for crying out loud, had sleepless nights for 2 or 3, 4 years, whatever the duration is. That's unbelievable. Does the appraiser have any recourse for something like that? Or
well, in an extreme case, and that one is pretty extreme. In an extreme case like that. First of all, there are mechanisms to recover costs, so court costs, but those are fairly minimal. And you can shift attorney's fees and costs in some circumstances under kind of rules of civil procedure, where you've made a settlement offer. Hey, we offer to let you dismiss that case against the appraiser for nothing. We're not going to pay you any money, but we're going to give you a chance to dismiss it and walk away. So you make that kind of a settlement offer. The plaintiff says, I don't accept. I'm going to keep suing you anyway. In that circumstance, in many states, a defendant like an appraiser can then seek, once they've won the case, can then seek to recover their, in some cases, attorney's fees, or in other cases, just costs, which would be like expert witness fees, deposition fees, that kind of thing. So in that particular case, the appraiser did get an award of some amount of their costs back against that homeowner, who incidentally was herself a real estate agent, so she really should have known better. Did get an award of costs against her, against the plaintiff. Might have been about $20,000. But in general, so that's the exception. In general, for a less frivolous case, for a case where there's maybe some merit in some sense to the plaintiff's case, and the appraiser wins the case, no, there wouldn't be a mechanism to recover fees or costs. And so difficult.
Yeah, it's so frustrating because, you know, I'm not a sue happy kind of guy, but when somebody attacks my integrity, you know, and my livelihood, quite frankly, you know, I want to defend myself, and I want to defend myself quite aggressively. I mean, I make mistakes. We all do. And I'm no saint. The saying I always use is, I'm not a saint. Ask my ex-wife. But when it comes to my businesses, I do not cross that ethical line. I mean, and I've lost a lot of money because I won't. You know, you can be ethical and be broke too. But so you mentioned settlement, and let's talk about that for a minute. And we're not talking about necessarily the E&O company that you were working for. I mean, I'm just talking general terms here. I read a statistic not long ago that tells me that about 95% of cases settle. And I don't know if that number's high. I thought it was a little high, but then I started thinking about this, and I think, all right, all the cases I've been involved in from a regulatory standpoint where I'm a consultant, you know, normally they're offering some sort of settlement. I do ad valorem tax appeal work as a consultant, not as an appraiser, not as a real estate agent, as a consultant. And gosh, Peter, probably 99% of all the appeals I file end up settling. All right. So as I got to thinking about that, I thought, man, maybe that statistic's right. More often than not, when an appraiser has to call their E&O company, you know, you just talked about a case that went to the Supreme Court. Is that common, or is that rare that you actually go and get a verdict as opposed to figuring out a solution to this?
Well, I think that statistic that you talked about, 95%, maybe 99% of all cases settling before trial, absolutely true across the board for litigation of any kind, not just appraiser litigation. But I do think that number carries over to appraisers as well. So I think it's an accurate statistic for appraisers. But really, it's not just about settlement. With an appraiser negligence claim, like that homeowner suing, there are probably three things that are most likely to happen. The plaintiff is suing this appraiser, and they and their attorney discovered along the way it's a lot harder to sue an appraiser than they actually thought at the beginning of the case. Most attorneys who take a case against an appraiser have never sued one before, and they don't realize the costs of doing that, hiring experts. They don't realize the work you have to put into it. And they also don't realize that there are a handful of attorneys across the country who have a lot of experience defending appraisers. And when an appraiser is represented by an attorney who has significant experience doing that before, they're going to be defended very efficiently compared to the plaintiff's attorney who's never done this before. And so in about a third of the cases, you'll see basically the plaintiff giving up after a while, willing to walk away and not demanding any money to do so. They've learned their lesson. It's hard to sue an appraiser. So that's really a third. So it's not always about settlement. It's about people giving up and walking away. Now, there
Right.
might be a small settlement in a case like that, and the settlement might be, we'll let you walk away and we won't pursue you for costs. Or in other cases, if there's an inkling of legitimacy to the case, there might be a settlement of, here's $1,000, or here's $5,000. But the plaintiff had originally been demanding $150,000.
Right.
So, that's just, that is a much better result for an appraiser than actually going all the way to trial in that kind of a scenario. Then you have the cases in the middle. There's actually some genuine issue with the appraisal report. It's a toss-up, who will win, who will lose. That could be a very bad situation if that goes to trial for the appraiser, because you could end up with a very bad verdict. Those cases definitely get settled, get worked out for some amount of a settlement. But again, that's where the appraiser actually, there is some merit.
Yeah, some errors.
And then there's the other third of the cases, just kind of in this frivolous category. Those wouldn't get settled. They would probably be won by the appraiser on a motion for summary judgment, so cut off before trial. It might be that, okay, the seller is suing the appraiser. Well, that's a really hard legal argument to make under almost any state's law, every state's law, basically. It's a hard argument. So I would anticipate that the appraiser will win that case before trial on a motion to dismiss or a motion for summary judgment. So now we're talking about, the 1 or 2% of cases that actually go to a trial. That's how it happens that way. It's not just because, the knee-jerk reaction of the E&O providers want to settle a case. Now, there might be some E&O providers that lean more to settlement. Then there are a few others that would operate more like with an attitude of, no, we fight cases. We don't want repeat offenders suing our appraisers.
Right.
At LIA, where I worked, we did spend more money on defense than we ever paid out in damages.
Oh, wow.
So that meant we were working harder on defense than writing checks.
Right. Yeah. You don't want it to be an open season on appraisers and your insureds when you're working for a company like that.
Yep.
That makes perfect sense. On the regulatory, and after our midway mark, which is coming up unbelievably, I want to talk about best defenses, how we can be defensive here. But on the regulatory issues still, I've got a lot of folks that call me with regularity. Hey, I got that letter, right? I've had 2 in the last week. I think that so many appraisers out there are just scared, rightfully so. And Peter, they're of the mindset, what do I have to do to make this go away? I mean, the initial reaction is fear and oh gosh, what's going to happen, right? But then it's almost like they're on a mission to, I want this. My daughter got a speeding ticket the other day. Sorry, Brooklyn. She got a speeding ticket, and she's calling me, and she's just an emotional wreck, crying her eyes out. And I'm like, baby, what happened? I thought she was in a wreck. I thought she got arrested. I didn't know what happened because she was so emotional. And I'm like, what's going on? She's like, can I come see you? I said, come on. I said, what happened? I got a ticket. I said, okay. They're not going to throw you in jail. You're not going to die. We'll figure it out. Just calm down. I think so many, and the funny thing about that is she's like, well, he said it's payable, so I want to pay it right now. I said, honey, it's probably not even showing up yet. Can I go to traffic? And she wanted answers right then and there. I'll pay it right now. I said, you're paying it. Dad's not paying it. She said, she was under so much stress, Peter, that she wanted that resolved then. And I said, you got to take a deep breath. It's not, call Monday and see what your options are. I think that's similar to what appraisers do. They freak out. Obviously, this is indeed a bigger issue than a speeding ticket, but they freak out. And where I'm really going with this is, if the regulatory board or the investigator comes out and says, hey, I think we can all make this go away, we can put an end to this. If you just sign this little piece of paper here, it's called an agreed order, or it's a consent order. You're going to acknowledge you made a mistake. We're going to make you take a class and pay $250, and then you can get on with your life. And so many appraisers just sign that thing.
Yeah.
What are your thoughts on that? Is that a good way to resolve the issue?
Um, it varies highly by the state. There are some states boards that are more difficult to deal with, and that where perhaps you are much better off doing a full fight. Then there are other boards that are they're fair. They're fair with it. So it's highly state specific. But it's the thing that I would tell appraisers when they get these complaints from a state board is, if you take that approach that you mentioned of, okay, let's be calm about it. It's not the end of the world. I'll give them this statistic. If you take that calm approach and you respond on the merits, you produce your work file, and you explain what you've done, then by the statistics I had researched this over a 3-year period, 88% of the time, the appraisers who got some help from the outside, an attorney at an E&O provider, supplied by an E&O provider, wrote and dealt with all the questions in a straightforward way. 88% of the time, those appraisers had no discipline that would show up in any public manner. So great. Either they were completely cleared, or they had a very minor form of non-public punishment or education, really. Take this class, but this punishment won't be public. So 88%. So that makes a lot of appraisers feel better right off the bat. And that was true, that the statistic was true on a nationwide basis over the last 3 years. So then, okay, now you've got the other 12% of cases. Okay, now you're really gonna have to work to defend that. And so the main thing is, an appraiser gets a complaint like that, they need to not suffer it alone. They need to reach out, start talking to someone like you is a great thing to do. Also, but very importantly, if they're insured, reporting it to their E&O insurer. For one thing, to get the help that E&O insurer can provide, like a recommendation to a good, experienced attorney in that state who can handle this.
Right.
And then, reaching out to others and working and getting their insight on it just makes that appraiser feel much better, and it does lead to a better result. But then you mentioned having a consent order in front of you. I would never want an appraiser to sign that without that outside input.
Right.
Because that appraiser has that one complaint. They don't know what the state board usually does. Is this extreme for this state board, or is this the best you can get with this state board? There might be something better that all you have to do is ask for it. So, for example, is the consent order saying that this punishment will be public, or is it going to be private? Of course, you'd much rather have it be private, and that might be something that you can ask for. But getting the outside assistance of someone who's done it before in that state can get you that knowledge of what do I ask for here.
Yeah, it's amazing. I have a dear friend, and she serves as a board member for a regulatory board. And she said, Bryan, we don't see these. If somebody is going to accept a consent order, we don't see it until they've signed it. And so then it just comes in front of us as really just a formality. And she said, I see some of these that appraisers are signing and agreeing to, and I'm thinking, oh, bless your heart, we probably wouldn't have even punished you to that extent of what you're agreeing to. So, by all means, get some help, get some consulting, get an attorney. So, Peter, unbelievably, we're already at the halfway mark. Hey, what's your favorite tool there behind you? If you were going to spend the rest of the day playing with something, what would you play with?
Well, the neat thing about my workshop is when I bought my house here 7 years ago, I bought it from a gentleman who was then 90 years old. And so he left many of his tools to me.
Oh, man.
So that was really special. And so he, now this is horrible. I'm looking over here to my left. He left me a table saw over there it's a Montgomery Ward's table saw, solid metal, no plastic on it. And it was built in 1952. and I have the original owner's manual and instruction manual for it.
Get out of here.
Yeah, so that table saw is older than I am, and I have used it to build fences around my house, cabinets. It's wonderful because it's so quiet.
I love it.
So,
I love it. That's awesome.
My second favorite is the chainsaw right there, and I
Yeah.
just leave it on the counter because it keeps me happy just every time I walk into the workshop to see a chainsaw. And it's not like I live in a forest.
Yeah.
Like, I live in California. It's a little bit deserty, so I don't have all that many trees to cut down.
I could definitely use that chainsaw where I hunt in Ohio County. Trust me. But I tell you, then that's the first thing I saw. We've got questions coming in. We'll get to as many of those as we can after our short little break here. But I saw the chainsaw as soon as I sat down. And folks, I literally got to visit with Peter 10 minutes before you saw us. We just got hooked up. So here's what we're going to do, just because Peter's got his saw there and told a great story. We're going to offer a 15% discount on any of our courses if you sign up right now using a discount code as SAW1952, SAW1952. I believe you said 1952, right?
Yes.
Okay. So Ben, if you could log that in so that our fine viewers can get a promo of a 15% discount on any of our Appraiser eLearning classes. And by the way, Peter just said a moment ago that square footage is one of the top things appraisers are getting sued for and turned in for and problematic. We've got a course on that. In fact, we got 2 courses on that. So you might want to jump on, grab one of those courses. I've got a course on CYA, talks about various issues that you might want to be careful on. SAW1952, SAW1952 is a discount code. And we'll run that for about 15 or 20 minutes after the broadcast as well. So that if you can't jump on right now and get that, buy a course, buy 2, buy 4, whatever you need to do is our way of saying thanks for being here. Guys, you're watching the Appraisal Report Webinar brought to you by the fine folks of Appraiser eLearning. These webinars are free of charge. It's our way to give back to you. We're not making any money on this today. This is free. This is informative. We bring featured speakers like Peter today. If you would like to be in the hot seat, or if you know somebody that you would think would be a good guest, let us know. Reach out to us. Tell us who you want to see, and we'll invite them to be on the program. These sessions are being recorded, so you can go back and watch this at any time. And finally, go ahead and hit the subscribe button. Subscribe to Appraiser eLearning's YouTube channel. You'll constantly be in the know. Woo, that took me a minute. All right, Peter, can we do some questions? I do still want to get to
one thing, Brian.
Yeah.
I don't know. You were the instructor for the class. I don't know if you know this, but I took your 4-hour online CYA class. I'm not an appraiser.
Yeah.
I don't need the CE credit. I just took it for fun to listen to you for 4 hours.
Oh my God.
It is a good class.
Are you asking for a refund? Is that what you're...
No, I loved it. I loved your class.
Well, thank you very much. Thank you very much for that, Peter. I'll give you $20 later for saying that. Thank you very much. All right. So we do have a whole stream of questions coming in. So let's go over some of these, Peter. If you're okay with that, I'll ask those of you, and we'll get through as many of those as we possibly can. Here's a comment or question from EL. He says, how was Cooper versus Baraka set precedent in California, and has it reduced actions of the state?
The thing about, I don't know if someone's trying to twist my brain there.
Okay.
Because I think Cooper versus Bracora is actually a decision in Florida, not California. There's hundreds of cases, so I could be wrong. Cooper versus Bracora is not important in California. I believe it's an important case in Florida. And the issue, and I believe the case concerned remember, we have no script, so
it's okay. It's all right.
It's just being thrown out there. I believe the case was about a homeowner suing an appraiser because the homeowner didn't discover termite damage in the home.
Okay.
They bought the house. The appraiser filed a summary judgment motion or a motion to dismiss the case and won because the court ruled that the appraiser did not have a legal responsibility, a legal duty to the borrower. So it's a very good case in Florida. Again, okay. I'm not sure.
Whatever state it's in.
Yeah, very good case in Florida for the proposition that an appraiser does not owe a legal duty to a borrower.
Love it. So let me ask you a question on that. This is Brian's question. So So if there is case law, and we're gonna get to another one in a minute, Tyndall, which I think you're familiar with. If there's a precedent set in a particular state, and let's say this Bacora was Florida, California, I don't care where it was, wherever it was, that's good for that state. But can that be referenced if I'm sued in Kentucky for termite damage, right? Even though that's not a precedent in Kentucky, could my attorney reference that and the outcome of that?
Yeah, if you had a specific case like that and your attorney was defending a specific issue like termite damage, they might start with some general Kentucky law, and then there's not going to be a public case reported in the appellate court on a specific issue like this. So yes, it would be persuasive to point out, hey, in this other state, here's how the court looked at that issue. So it's not precedential, but it's persuasive to the court. So something like that can definitely help an appraiser in any state.
And here's the thing, folks, an attorney, if you go to your regular doctor, what if they find something, hey, there's an issue with your heart, we need to they send you over to a cardiologist. If you go into the doc, the doc says, hey, how you doing today? What brings you in to see me? This isn't your regular scheduled visit. And say, hey, doc, I got this bone sticking out of the back of my leg. Oh my Lord, let's get you to ortho, right? Your general practitioner doctor is not going to handle everything. They're going to send you to a specialist regarding whatever your health problem is. Well, if we're talking about a value problem, right, it makes sense to go search out those valuation experts or attorneys that deal with value, not just an attorney that deals with divorces or estate planning. I want an attorney on my team that knows and is familiar with what I do. Peter said he's not an appraiser, but he takes appraiser education. I know you know Craig Capella, and I was trying real hard not to mention his name today.
Why not? I love it.
Yeah, he's awesome. So Craig is an attorney I consider a friend out of Chicago. And it was funny. We were at the ACTS conference in Salt Lake, and I was standing with a guy, and he's like, I could be an appraiser. Wasn't Craig. Another gentleman said, I could be an appraiser. Ask me a question. I said, great. What's the 4 economic influences that create value? And he's like, I said, what's the 4 criteria of highest and best use? And he's like, Craig's over here spouting them out. I'm like, Craig, you need to be an appraiser. It was awesome. And Craig's like, Peter and I take these classes. This is what we do. All right, here's a question from Stan Lee. I have found that 1% of brokers/agents actually confirm building size. They use a CYA referencing the county and telling the buyer to verify. I guess that's a statement. Doesn't look like a question. In Kentucky, we are required to adhere to ANSI as appraisers. And our local, where I live, our local board of realtors it doesn't say the agents have to measure, but it says that the agent needs to verify that they were done. I'm not sure how they're doing that. Michael H. says there would be an attorney behind that woman who filed the complaint about square footage. This is a good question, Peter. So the square footage issue, I believe, was the one that you were talking about, the Supreme Court. He said there had to be an attorney behind that woman that filed. This is Michael H. His question is, does the attorney have no obligation to find out facts?
They do have a general obligation to not file frivolous lawsuits. And in an extreme case, an attorney could be sued for malicious prosecution, just as their client could. So in an extreme case where there are no facts and the lawsuit was objectively unreasonable and filed for an improper purpose, that part is important. An attorney could be liable for malicious prosecution. And I have seen that in appraiser cases.
I guess that what I'm hearing is it's almost would be unethical for an attorney to proceed with a lawsuit when there's no basis.
Oh, absolutely. If there's no basis, and the appraiser and the attorney does have potential liability, but it takes a very extreme case. Years ago, we had an attorney in a state near you who filed 8 different lawsuits against appraisers, all for different homeowners, and he kept, like, the first 3 or so got dismissed, and then it was 8 different lawsuits against the same appraiser, and all for different borrowers. And as the first 3 or so got dismissed on a real technical legal issue, he should have been dismissing the others, but he didn't. He wound up getting sued by the appraiser, and the appraiser wound up getting damages against him in a settlement against him and his insurer.
Goodness. Here's another question from Mark. Mark says, what, if any, potential liability issues do you see with the 1004P product? Would an extraordinary assumption override LC5 and certification 1213 reporting adverse condition repairs? So for all our viewers that don't know what Mark's talking about, which there probably are several, the 1004P is a pilot program. You guys have heard of hybrids for a while now, and the new big buzzword is bifurcated, right? Bifurcated appraisals. I'm just finishing up writing a new course. I'm actually going down to Texas. I'll be in Dallas August 10th for a few days. I'm going to moderate a USPAP panel down there, and then I'll be teaching my new course, the appraisal inspection. And we talk about bifurcated appraising and hybrid appraising, but it basically is more of a course about what do you do when you go out and do an inspection? What should you be looking at? So a 1004P is a pilot program for, I believe, Fannie Mae. They've put together this form because they're testing having other people do the inspection. So Peter, I don't know how much you're up on this, but do you want to take a stab at that question?
Yeah, I've seen the form, and I've seen a lot of other bifurcated type products. You know, it's kind of the Wild West right now on bifurcated appraisal products.
Okay.
The main thing I don't like about the 1004P and some of the things I'm seeing is when they carry over. I'm not so concerned about those certifications. What I'm concerned about is certification number 23. That's in the 1004 form already. Certification number 23, what it says is that the borrower, I can pull it up.
The borrower, another lender at the request of the borrower, and a whole host of people can rely on your appraisal report. In 2005, when that form came out, my stomach got upset when I read that.
Absolutely.
Because prior to that, I could make an argument, or my attorney could make an argument on my behalf, is that, hey, you weren't the client, you weren't the intended user, therefore you can't use the appraisal or appraisal report, you shouldn't be able to rely on it. Well, certification number 23 changed all that. It says the borrower can rely on it.
Yep.
So yeah,
it literally says the borrower may rely on this appraisal report, and that opens the door to the fundamental underpinning of a negligence claim against an appraiser, that element that does the appraiser owe a legal duty to the borrower. And certification number 23 opens that door. We might be able to close it if the appraiser does something else in the report. So that's my main worry of what I'm seeing. And I'm trying to talk to people who are designing these forms. Really keep that one out. If you're going to have appraisers doing these bifurcated products, keep that one out, because 65-70% of lawsuits come from borrowers, just like those regulatory complaints. And
so let me ask a question on that. I put a statement that basically says, I'm not a home inspector, I'm not blah 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 blah, and the buyer or borrower in this case should seek those individuals out and satisfy themselves about the condition of the property. Now, my thought on that, Peter, is if 3 months from now somebody says, well, you check this box on page 1 of the report that says there's no physical issues, and if we remember back to the old form prior to 2005, it used to say there are no apparent adverse condition, and they remove the word apparent. I like apparent. I want it back, right? Yeah. So they come and they say, I'm going to sue you. I have four rotten floor joists. You said there are no problems on page 1, and certification number 23 says I can rely on your report. I'm going to sue you. My response to that would be, if you relied on my report, why didn't you rely on the section of the report that says don't rely on my report?
Yeah.
I don't know if that helped me or not.
It would help you. But,
okay.
Let me try to pull up something on my screen. Will you let me do that?
Yeah, absolutely.
Okay. We'll see how this goes. see if I can do this. I'm going to pull up a document. All right, let me know. Are you seeing
Yeah,
okay.
we got it.
So in the middle of the screen right here, this is the language I like to put in any kind of residential report, whether it's a 1004 or similar report form. And it goes directly to that issue of, can the borrower or even a seller, because we get seller claims too, really use and rely on that report. Now we can't throw out certification number 23, but we can at least try to, what I would call, clarify it. Now this is a major clarification, but we don't get lenders, AMCs rejecting reports when they have this kind of language in it. And I've been recommending it for probably 8 years. And the language is specifically designed based on some of the case law that's out there, including another case that I see mentioned in your questions. And so it's right here. The appraiser has not identified any purchaser, borrower, or seller as an intended user of this appraisal, and no such parties should use or rely on this appraisal for any purpose. Then such parties are advised to obtain an appraisal from an appraiser of their own choosing if they require an appraisal for their own use. Then one more sentence. This appraisal report should not serve as the basis for any property purchase decision or any appraisal contingency in a purchase agreement relating to the property. That's when we see that appraisal contingency box checked in a regular purchase agreement.
So Peter, are you saying that folks can use that? They can use that. You don't care if they plagiarize you?
Oh no, it's language that at any seminar I'm in these days for the last 10 years, I've been recommending to appraisers, and it's like scientifically designed to match up with the case law. That when an appraiser gets sued in a state, we've got all this case law out there that's beneficial to appraisers right now. And the case law has become very favorable for appraisers versus borrower and seller type claims. That language just magically ties into whatever the actual language was in that case decision. So now the appraiser gets sued. The appraiser can file a motion to dismiss. Oh, look at my report. It magically has similar language. Dismiss my lawsuit too.
Right. Absolutely. So all of you that are viewing, I mean, Peter was gracious enough to put that up there, and he just said that you could use it. I screenshot it, so I already got it when you had it up there. And everyone else, just go back, watch this recorded, hit your snipping tool or snag it tool, and you can actually grab that right off the screen. Peter, thank you for putting that up there. That was very, very nice of you to do that. Let's talk about more defense, by the way. All right. So we've only got a few minutes left, and I want to capitalize on your time as much as I can. What would you say is, this is a defensive move right here, trying to protect ourselves, right? I think generally appraisers try to do a good job. I don't think, there's some unscrupulous people out there, but I think for the most part, appraisers are a pretty good, conscientious group of people. And I think they try to do the right thing. But it is scary. It gets scary, especially with somebody doing a frivolous lawsuit or a frivolous complaint, and then it opens up a whole can of worms, right? Being put on there. Everybody wants to know where they can get a copy of that. We'll talk about that at the end. Hang tight, people. It only cost you $19.99. No, I'm kidding. So what are some other ways that we as practicing appraisers can protect ourselves?
Well, I'd say dealing with that threat when it first gets made appropriately. And you hit on it when you had that example of the homeowner who said something about the square footage in your report, and really the room hadn't even been built.
Right.
And you, first of all, you responded to the woman who had that complaint. She called you up. She probably left you a phone message, right? Or something like that. And you didn't ignore it. A lot of appraisers will actually ignore that call. They'll rationalize, oh, this person who's calling me is not my client, not an intended user of the report. Because she's not my client, I have this duty of confidentiality. I can't even talk about the assignment with her, right? But that's not quite true.
Right.
under USPAP's confidentiality rules. So you did get back to the woman, and you listened to what her concern was. You did say, I think I remember you saying, I have this duty of confidentiality. I can't talk about the report with you. That can be a very nice shield right there, because you can then explain, oh, my work was for the benefit of the lender.
Right.
And I do have this duty of confidentiality to them. So you've done two things there. You've responded to the person, so that wound is not festering. If you don't respond at all, that wound is going to fester, and they will file a complaint or they will sue you. So getting back is important, getting back professionally. Okay, now what's your next move? Okay, USPAP confidentiality and who your client is, a little bit of explanation there. That might be enough right there to shut down the complaint.
Right, right.
Okay, but then you've at least now, if that doesn't shut it down, at least you've gotten some information. What are they unhappy about? You found a way to resolve it, because there's like the plans, you had been shown plans and they had extra space on them. At that point in time, once you've heard the problem, now reach out to other people, your E&O provider. Hopefully they'll have a good resource to talk you through the situation, and now start working on the specifics. So those are really the main things to deal with a threat. That's as important as having great language like I just showed you in an appraisal report.
Yeah. That reminds me of I appraised a house one time, and it's in a rural setting, but it's a little subdivision actually. And the homeowner, I mean, he gave me the best comp. he said, that one over there just sold, because I always ask him. And so I did the appraisal report. I turned it in, and let's just say, needless to say, he wasn't happy with my opinion of value. And he called me, and he wasn't screaming or anything. He just said his big thing, Peter, was somebody else, another certified appraiser, appraised it a year ago and was $2,000 higher than where you're coming in today, Bryan. How could my house have went down in value? And this was way before the housing crisis. We weren't having declining markets. If anything, we had increasing. And I was trying to tell him, I never said, I didn't say your home did go down in value. It's just merely a difference of opinion between the other appraiser and myself. But he couldn't get that. He kept focusing. And so what I did was I didn't ignore his call. I did talk to him. I turned it around. I said, what? He said, I said, what is it that you do for a living again? You're a school teacher. He said, yes. I said, well, let me ask you a question. If you gave your students an essay, and they go write the essay, and they come in and bring it the next day, and you grade them, and in your heart, you really believe this essay was deserving of a B, and you gave them a B+. And those parents came in and were screaming at you saying, my son needs an A, should be an A. Would you change that grade? And he said, well, of course not. I said, well, that's what you're asking me to do. I said, I've developed this opinion. You might not like it, but this is my own independent, unbiased, I said, professional opinion. And he concluded by saying, well, Mr. Reynolds, you were very polite when you came out and looked at my property. You told me what you were going to do. You spent about 45 minutes out here. You measured the house. You were extremely professional, but I'm never going to use you again. I said, that's fine. That's your right. But at least we were able to have a grown-up conversation. And while he still wasn't happy at the end of the day, he wasn't going to go file a lawsuit against me or file a complaint. So I think what you said is critical. If you just ignore, nobody likes to be ignored. If you call somebody up and they don't call you back, isn't that frustrating? If you call them again, they don't call back, you're going to get mad. And you're right. They're going to probably file a complaint if you just try to avoid it. Peter, talk about work file for a minute. And I know we're minutes left here. Tell us about work file. I know that I was an investigator for many years, and they'd send in their appraisal report and their work file. And man, the work file was just there wasn't anything in there. What do you see with that? Is that an area of concern for appraisers? Do we need to do a little bit better job?
Absolutely. I'm sure when Craig's been on with you, he's talked about the work file too. That work file, it becomes the appraiser's defense toolkit when they're legally threatened or when there's a state board complaint. So hopefully everything is in that toolkit to support that appraisal. And so, yeah, the work file is vitally important. And one of the things on these bifurcated reports or appraisals that are being done, so much of it's being done in the cloud now, that I have seen some state board complaints against appraisers doing the bifurcated appraisals in the cloud. And in a couple of the complaint situations, the appraisers did not even have a work file.
Oh,
so,
gosh.
yeah, it's really scary. You got to remember that work file it's USPAP required, of course, but it's also your defense toolkit when a claim comes about.
You know, what you just mentioned, and I want to let appraisers that I'm talking specifically to the appraisers that you just said that don't keep a work file. I mentioned a moment ago, I'm collaborating with an appraiser over in Indiana. We're doing 10 schools. We're analyzing rent schedules for 50 schools, right? Greg's keeping the work file. It's okay. I have access to it. You know, there is a work file. He has it. All right. For those appraisers out there that aren't keeping a work file, we have a record keeping rule now. So you're probably in violation of the record keeping rule. However, there's a provision in that says if you willingly or knowingly violate the record keeping rule, you are now also violating the ethics rule. So you have an ethical obligation. You know, if you make a mistake, I didn't have something in my work file that I should have. Oops, that was an honest mistake. I'm sorry, Peter. You know, I've got a violation of the record keeping rule. But if I willingly or knowingly violate that, now I've got bigger problems. I've just violated the ethics rule, and ethics is a real big problem. Hey, Peter, we're out of time. I could talk to you all day long. Maybe we'll have you and Craig on together sometime. But I definitely would like to have you back on the program if you're open to that. I know you said this was your first YouTube experience, but we'd love to have you back on.
Thanks for getting me through my first YouTube appearance. And Craig is a close friend. He's a close friend, and I'd love to do something with him. We've given several presentations together at different spots in the country.
Yeah, I've seen you on some of those, and unfortunately, I have a habit of polishing off my presentation moments before I go on. Okay, maybe I'm writing it before I go. But so I haven't had an opportunity to see yours in its entirety, but I will be doing that. So let folks know, our viewers, if they wanted to come hear one of your presentations, Peter, how can they find out what your schedule is, where you're going to be, that type of thing?
Actually, at LIA, they've got a section of their website where they list the presentations I'm doing for them. Okay. So that's liability.com. There's a list of all the presentations in the next 6 months or so. The next place I'm going to be at will, let's see, actually be in October, I think, in Concord, New Hampshire, with an Appraisal Institute chapter there.
Great, great.
I'll be talking out here in California. We have an organization called the California Real Estate Appraisers Association. So I do a lot of talks with them. That's in September. That's actually in September.
September. Okay. Yeah, I know I've seen you at the summit before. I don't know if you're going to be out this time. That's in September in Vegas.
I am. I will be at the summit. Yeah.
Okay, great.
There too. So
Peter will be speaking at the Appraisal Summit in Las Vegas in September. I know you were at the ACTS conference in Salt Lake this past April. I don't know if we've got you on the agenda for the next ACTS conference or not, but we need to if we don't. So if someone wants to reach out to you, they want to communicate with you outside of traveling somewhere to see you in person, how can one get in touch with you?
Well, I do have a very simple website. It's valuationlegal.com. There's one thing that all appraisers might be interested. You know, of course, I only practice law in California, and I can help on legal matters outside of California, but you know, I can't represent someone in court outside of California. But I do help firms and even AMCs on legal issues that span multiple states. It's just I can't represent someone in a different state. But on my website, I do have a chart of every statute of limitations in all 50 states.
Nice.
And that's something that's the most common question I'm asked about by appraisers. What's the statute of limitations in my state? Does this discovery rule thing that I hear about apply in my state? And so gone through every state, and I've got a chart there on valuationlegal.com.
Fantastic, fantastic. So, guys, get on that. The little commentary that Peter put up earlier, I will get Ben a copy of that, and anybody that wants that can reach out to Ben or myself, Bryan at appraisereLearning.com. We'll get that to you. Peter Christensen, thank you so much for being here. We really appreciate your time. I look forward to having you back on again. Tell Craig I said hello when you speak to him, and we definitely want to get you on the schedule for a follow-up. We just ran out of time, and there's so many things and avenues that we could go off on in this topic of appraiser risk, appraiser liability, how to protect yourself, and so we would love to have you back on again real soon.
All right, thank you, Bryan.
Ladies and gentlemen, you've been watching the Appraisal Report webinar brought to you by Appraiser eLearning. Don't forget Saul 1952. Peter was gracious enough to tell us a little stories about his table saw from the 90-year-old gentleman he bought the property from. What a fantastic thing for him to do, is to give you those tools. I mean, what a fantastic gesture of that. His favorite tool is the table saw that was built got in 1952. His second favorite is the chainsaw that we see pictured behind him, and that's why we're doing a promo code SAW, SAW 1952. It's for a 15% discount on any of the Appraiser eLearning courses. He mentioned the ANSI guide earlier. He mentioned my course, CYA. I'm flattered to hear that he took that course and didn't beat me up too bad with that. So jump on there while you've got about 15 minutes left to get that discount code. Thank you very much for watching. We hope to see you again real soon. Thank you very much.